At the instant when you are officially charged with the crime, the criminal justice process begins. The arrest consists of law enforcement taking the suspect into custody. This arrest must be done with probable cause. The suspect is then read their Miranda rights, which makes clear the rights that are afforded to them and that they understand them. Booking. After the suspect is taken into custody, an administrative record is made. This includes their name, photograph, and fingerprints. It is important to note that the suspect can be released after booking and then rearrested for the same crime if more evidence is found. This works as a filtering process. Preliminary hearing. The suspect is told by a judge of their specific crimes and a bail is set. The suspect is taken in front of a grand jury or a judge, depending on the crime, to decide if the evidence warrants a trial. Arraignment. At an arraignment, the judge again reads the official charges and the accused has the option of pleading guilty, in which cases of punishment is usually decided by both sides. But the suspect can plead innocent of the charged crimes, in which the case goes to a trial. Trial, the most dramatized portion of the justice process. The trial consists of a prosecutor, defender, judge, and jury. The prosecutor argues guilt and the defense innocence, while the judge makes sure it is a fair trial. It is the role of the 9 jury members to hear the evidence and arguments and hopefully correctly decide guilty or innocence. Verdict. If the jury rules guilty, a sentence of punishment is given. If the defendant feels that it was a mistrial, they can appeal the case to a higher court, who can choose to hear it or not. The case can go all the way to the Supreme Court, but few appeals go that far.